I want to just start by addressing some of the comments that the good chairman of the Judiciary Committee opened up with. And I think the very first thing he said is that this is a bill that has been with us for several years. And while the concept has been with us for several years, I just want to point out that we are now debating a bill that it says on the big board up there as amended. And in fact, it was a strike-all amendment. So in fact, this particular bill has only lasted for as long as we've been talking tonight. And while this language has been worked on for a considerable period of time, the actual LCO number 5156, I believe it is, that's before me, I've only had since just before we began talking, which I can tell you is not the way we ought to be doing business on any issue, and certainly not one as controversial or as sensitive as this. It's just another thing that I will add to my list of concerns about the way we do business beyond the actual business that we do conduct. The other thing I would say is that he opened by stating that this is not a gun control bill. And I'd say that's a debatable point, and I think that we are going to indeed debate it over the next several hours. But what I would absolutely say is that it is not merely a domestic violence bill, because if it were, there would be no significant debate. If it was a bill that was dedicated solely to protecting the victims of domestic violence, as was stated by Representative Rabimbis, the ranking member of the Judiciary Committee, it would pass this chamber unanimously, and it would fly out of here with little debate whatsoever. The mere fact that that's not what's happening ought to be proof to anyone watching that this is not just about protecting victims of domestic violence. I certainly want to help protect victims of domestic violence, and every person in this chamber, I'm certain, agrees. So if there's anyone who's going to oppose this legislation in the end, it certainly cannot be because of that. So I just want to dive in a little bit, maybe at a 30,000-foot view at first, to kind of talk about what we're doing here. I'm pretty passionate about this issue because, to me, this bill is partly about guns. It is partly about domestic violence. But to me, it's more about who we are as a people and the rule of law. The fact is that we are charged as individual legislators to try and improve the situation that the citizens of our state live each day in. But we have to recognize that we are also charged to stay within our limits and our bounds in doing so, because we are a legislature that works for a free people, people that should have the right to make their own decisions and determinations in life. And I'm generally, when debating a bill, often going on about how, do we need this bill? Do we really need another piece of legislation to tell people how they should live their lives? And the other thing that is important when we consider that the people we represent are free people is that they have rights. They have rights that we have established as inalienable in our own founding documents, and we have crafted in our system of laws and government a way to protect those rights, to make sure that the government, both federal and state, does not exceed our authority in interfering with the lives of the people we represent. And that's precisely what this bill does, and it's the reason why I'm standing here. It's because people have rights. Since last year, I've been involved in a discussion with members of my own party, members of the other caucus, and people outside of this building about this legislation and what we could actually do to improve the situation that this bill that's before us claims to be concerned with improving, and that is to address the concerns of the victims of domestic violence, and particularly for what is described as the most dangerous period of time, which is the period of time between someone is served with a temporary restraining order and the date of the hearing where the subject of that restraining order will have their day in court, and that day is 14 days later typically. I fully recognize that's a concern. I understand that it's something that we ought to address. And when this similar legislation was put forward in previous years, my first reaction was, well, why don't we move that hearing up so it happens immediately? That would seem to make sense. That way that person can get their restraining order filed immediately, but the person who has to respond to it also has an opportunity to defend themselves in court immediately. Seems like a perfectly logical result, response, and solution to the problem. But yet, that's not what's being done here. As a result, we end up with legislation that I believe is not very well thought out, and myself and others, and the previous speaker pointed out several things that are completely unclear, using the term immediately, but not more than 24 hours. These are two entirely different things. Which is it? Just an example, many, many other problems with this legislation before us. It's not well thought out. I don't know that it will work well in practice, and it is certainly unconstitutional. But I'll say one more thing about it, and I think it's going to be completely ineffective. You know, I think this legislation comes before us for a lot of reasons, but gun control is certainly one of them. During the public hearing and over the last several weeks that this legislation has been floating around this building waiting to be called, the people that I heard calling for it the loudest, were not people interested in domestic violence. They were people interested in gun control. Many of the people that came forward at the public hearing were members of organizations that were gun control organizations, not domestic violence organizations. There has to be a reason for that. The thing is that I think that there is, with some people, a desire to ignore the fact that guns are just tools and that they can be used offensively but also defensively. And I would venture to guess that in our society, firearms are actually far more often used defensively. And while this bill claims to help protect the victims of domestic violence, I am fearful that in some cases it may in fact exacerbate the problem. So let's just cover what this bill does. As I said, when someone currently applies for protection via a temporary restraining order through the courts, essentially what happens is the court will review a document that's provided to them, referred to as an ex parte restraining order application, which is nothing more than an affidavit. It's a statement by a single person making a claim at why they deserve to be protected from some other person. In keeping with our laws and our protections and rights as a free people, the people that drafted the original legislation recognized that the person being accused would have a right to have their day in court and provided for a hearing in 14 days. They also saw fit to see that if there was an issue of firearms involved, that those firearms could not be confiscated or ordered surrendered until that 14-day hearing occurred. And I brought this up in the committee meeting on the same subject, that I think it's pretty darn clear that the reason why they did that is because they felt they had to. They felt that they would be violating our constitutional principles of due process if they didn't provide for the opportunity of the person being accused to have their day in court before losing a fundamental constitutional right, equal with the right to free speech or the right to vote. This bill changes that situation so that if the person applying for the restraining order to the court indicates that the person who is the subject has firearms, if that restraining order is approved, if the court sees to believe the affidavit is enough to determine that it is worthwhile, they will go ahead and issue the restraining order, and that restraining order will also require the respondent to surrender their firearms immediately, but not more than 24 hours, which we will discuss further what that means exactly. In that case, the person who is the respondent has no due process rights whatsoever. They never get to say, gee, I'm really the abused person. I am the victim here. The person who is telling you to take my firearms away is the person abusing me. They never get to say their piece in court whatsoever until after their firearms are taken from them. And we've had many, many examples that came before the Judiciary Committee during the public hearing of people who were in similar situations, even without this law being enacted, where they were put at a disadvantage by someone who is actually the abuser. Now, I realize I might be talking about 1 in 1,000 cases. I get it. But there's a lot of things worth considering when you look at the figures for how many people file restraining orders, how many of them actually become permanent restraining orders, and all of the different details that are involved. And I promise to go back to that. I just want to kind of stay on track about what the bill does. So, what is due process? Due process is the concept that we are innocent until proven guilty, that we should have the right to face our accusers, and that we should be able to provide for a defense. You can think of almost no other case in our system of laws and justice where someone is deprived of property or freedom or anything without having an opportunity to be heard. In fact, it's funny that I just said that because the very first version of this bill I ever saw, that's all it was brackets around the words "an opportunity to be heard." And I remember asking the Lieutenant Governor in a public hearing in the Judiciary Committee, how does that sound like it could ever be a good thing, that we just take out an opportunity to be heard from a bill? An ex parte restraining order is exactly that. It is a one-sided document. As I said, it's a statement from a single person about a subject. And somewhere in my pile of stuff here, and forgive me, but I have 20 versions of this bill in front of me, so I have to keep referring back to which one I wrote my notes on. The problem I see with this is that temporary restraining orders have historically been granted for very, very wide-ranging, let's say, reasons. And while many of them are going to be perfectly legitimate and someone is going to state the facts about how they are being abused and they are genuinely in fear of another person and the court should rightfully grant it, there are plenty of applications that are made for other, let's say, less notable or less worthy reasons. And I have before me an article that is from the Connecticut Post. Now, granted, this is from 2010, but it just cites a couple of reasons why people have applied for restraining orders. A Bridgeport man recently applied for a temporary restraining order to prevent his future in-laws from coming to his wedding with their daughter. Another guy came in because he claimed his dog was speaking, his neighbor's dog, was speaking in tongues to him. And then I think there was another one in here, which I thought I had it highlighted. But it was something to the effect of this gentleman thought that his mother-in-law was poisoning his contact lens solution. So just to use those examples, do we really think that those are worthwhile reasons why a court should be able to issue a restraining order against someone that not only keeps them away from the other party and maybe their home, but also would restrict their ability to own firearms and would actually cause them to have to voluntarily surrender their property within 24 hours or immediately, as the bill says? Part of the problem with this thing is that I think that the TRO legislation that currently exists is a civil remedy, and what we are trying to do is ascribe a criminal solution to it. And in fact, there is existing law that handles 99%, I would say, of what the concerns are being put forward as in this bill. The fact is that if you are truly in fear for your life because someone has threatened you or abused you, especially if it's happening in the middle of the night, I believe that most people's immediate reaction would be to call the police. Not wait until Monday morning at 9 o'clock to walk into a courthouse to file a request for a temporary restraining order. Both worthwhile endeavors, but for an entirely different purpose. We have an existing law that's been talked about a little bit earlier tonight called the risk warrant statute. And this bill essentially says, or this law basically says that if you contact law enforcement and you make a good enough case to them that you are actually in fear for your life, they will do an investigation, although it might be a very brief investigation that only involves questioning a couple of folks. If they reach the conclusion that they believe that they have probable cause, and that's the key, they have probable cause to believe that there is someone in danger, they can immediately go and find that person and take their firearms from them. As opposed to this solution, which essentially creates a time frame where they will be served with a restraining order and asked to voluntarily surrender their firearms. One of the things that keeps being brought up to me is that the reason why the risk warrant statute is not viable is because there are many people who do not want to go to the police because it generates some other type of concerns. Maybe they have fears of the police themselves, or they don't really want the other person to be arrested. Who knows? The thing about this bill is that one of the provisions in it is that once the TRO is issued, it's going to be the job of a marshal to go and deliver it. But the police in that town will be notified, and the marshal has the option of asking a police officer to accompany him to go deliver the TRO. And I can tell you, I know a couple of marshals, and I can tell you if I was a marshal, you can be darn sure if I was being asked to go visit someone who has been found worthy of receiving a TRO because of some sort of domestic abuse, and they have firearms, I would be bringing that cop with me. So I don't think we're avoiding any contact with the police whatsoever under this legislation. So that makes me wonder. I also think that if there is a concern that somehow involving the police is somehow going to make temperatures rise and create an environment that might, in fact, increase or exacerbate the likelihood of something horrible happening, I think given the opportunity of having the police immediately address the situation by going out and finding that person and taking their firearms away from them immediately versus having someone go out and tell that person, oh, by the way, you have to voluntarily surrender your firearms. I think I would choose the first also. Imagine someone who is so enraged already that they are considered a danger, and now they're going to be told that they have to surrender the implement that they might cause harm with, voluntarily. Let's think about something else, too. What about the judges? You know, I have a concern because I looked at the statistics over the last several years of all of the restraining order applications that have come before the courts and how many of them were granted as ex parte, one-sided restraining orders, and then how many of them became permanent. And just looking through the numbers over the years, and again, I mean, you can correct me on this, but it's about half, it looks like, every year. So two things I would say about that. One is, to me, that's scary, because that means that in half of those cases, essentially, there was no merit found to turn it into a permanent restraining order, or at least the situation that caused the temporary restraining order has now passed. But you have to see that in some of these cases, the judge, when faced with the accused, decided that a permanent restraining order was not warranted. So that tells me that some of these were not worthwhile to begin with. And the other thing is that I think that in an environment where we are putting a judge in a position of deciding whether or not someone should have their firearms taken, they're going to always say yes. I mean, imagine being a judge. Do you want to be the guy who, despite the fact that you don't think the claim has any real merit, do you want to decide against doing that? And then ultimately, something happens? So I think you're creating a situation where we're putting our judges in a bit of a predicament. I'm also told that if you get arrested for domestic abuse, that's actually happened, not a mere threat that might generate a restraining order, but if you were actually arrested for some sort of domestic abuse, you have 48 hours to surrender your firearms. I don't know why we would create a penalty that is greater for someone's one-sided claim versus something that has actually happened. The mechanism in this bill that has the person surrender the firearms is absolutely gun control. It is confiscation of firearms. I just mentioned that if you get arrested, one of your options when you are relieved of your firearms, besides turning them over to the state or to a federally licensed firearms dealer, is to have someone who has a permit to carry and is eligible to have those firearms hold out onto them for you. In this instance, that has been removed. So you are left with only two options, which is to have your firearms given away to the state. And there are some concerns about how they will be returned. I noticed that during the previous conversation, there was some discussion about how they have to be returned after 5 days. But there's no enforcement mechanism. And I've been told by folks that have to deal with the courts whenever they take people's property, they are pretty lax about returning it. They might have instructions to do so, but there's no guarantee that they're going to actually return anybody's items in a timely manner. And again, you might say guns, but guns are not the issue here. It is a fundamental right that we are guaranteed under our Constitution to keep and bear arms. And the solution of either having to hand your firearms over to the state or to sell them rises to what I can only describe as confiscation. I'm curious to know if an amendment might be coming up on the subject of allowing someone who is a eligible party to hang on to the firearms. Just throwing that out as encouragement to one of my colleagues to maybe come up with that. And again, forgive me, Mr. Speaker, I have tons and tons of notes because I wrote all over the multiple LCO numbers that I had before me, and I thought I was going to be able to keep that straight. But while you're talking, it gets a little more complicated. I'm just going to finish up with what I started with, which was that I said that I believe this bill, not only is it unconstitutional and flawed, but it's also not going to work. And to describe why I think so, I'm going to point to another newspaper article. This one is from just the 10th of March of this year. And this is an incident that happened in West Haven, Connecticut. And it starts by saying, a West Haven man was arrested Wednesday night after police say he assaulted and choked a woman, then tried to hit her with a boulder outside a city apartment. The interesting part happens when you read on and you realize that this guy was under a protective order already, and he did not need a firearm to hurt the person that he was abusing, but he also did have two semi-automatic firearms in his apartment. One with the serial number taken off, and the other one actually had 15 rounds in it, which I found amusing since we passed legislation here saying that was illegal. And I have repeatedly pointed out that only law-abiding citizens are ever going to pay attention to that. And it's not surprising that this criminal abuser had 15 rounds in his gun. But my point is, there is no piece of paper that's ever going to protect anyone. And I believe that we have a mechanism in our law that satisfies all of the concerns that the proponents of this bill have, which is how to protect someone who is being abused or the potential victim of domestic violence, and that is the existing risk warrant statute. Now, I recognize that it's not a perfect system, and we have actually introduced other legislation that passed the Judiciary Committee unanimously, I believe. It was House Bill 5597, which essentially took the existing law regarding risk warrants and basically set up a system whereby if you went into the court and you were looking for a restraining order, someone would ask you if this rose to the level of immediate fear and danger, and if so, you could check a box, and this would immediately go down the path of the risk warrant statute so that you could actually have someone in law enforcement start to take care of that immediate concern as it should be, not through a slow civil court process as this bill intends to do. I think that the legislation before us, while it might have a fancy title that leads people to believe that they're doing good, is so poorly written that, in fact, it was going to end up confusing the court system and leaving some people who would otherwise have been in a situation to protect and defend themselves defenseless. I can't abide by that. And especially when you consider that we are basically decimating the rights of our citizens in the process by telling people that they no longer have the right to be presumed innocent or to a hearing before their property is taken. I can't imagine what means we would use to justify such a thing, especially when we have a mechanism in our current law. I know that there's plenty of people who want to speak on this bill, and I know that there will be amendments offered, and I will look forward to hearing more in the debate, and I will certainly try and add to the conversation when some of the amendments come up. But I would encourage everyone to think not just about the title of the bill as what it does, but actually what's happening here, and be thoughtful about the legislation that we put forward and try and do something that actually solves the problem without taking advantage of someone's rights. Thank you, Mr. Speaker.